Right, everybody, we might make a start. So I'm just going to welcome Erin on behalf of GWI. So Greg and Lisa have done all the work in organising this seminar, but this is one of the sessions in a series that they've been organising throughout the year, so thank you very much for coming along. So Erin is a lovely person and is a research fellow at Melbourne Law School. She's had a recent book published, Legal Rights for Rivers, Competition, Collaboration and Water Governance, and she's been appointed to the Veron Council trustee body. You going to talk about that?
Yes, I certainly can.
You can fill us in the talk. And personally, I find this a very interesting topic. It's something that the connection between environmental law, water law, and rights for nature is something that's growing very quickly. It's been around for a long time, but it's got a lot of contemporary popularity now, and it's taking shape on the ground in a lot of different ways. So I'm very interested to hear what Erin has to tell us about that. So I'll hand over to her.
All right, bear with me. I'm going to try and talk into this microphone so that we can record it for the people who aren't able to be here. Thank you so much, everybody, for coming along today. I'm really looking forward to this conversation. Before I get started on the presentation, of course, I would like to acknowledge the Gadigal people and the Eora Nation as the traditional owners and custodians of the land on which we're meeting today. I would like to pay my respects to their elders, past and present, and also pay my respects to any Aboriginal people here with us today in this lecture theatre. I think it's always important to kind of pause and sit with that acknowledgement of country, but I think particularly in this context. So legal rights for rivers, legal rights for nature is an idea that's resonating in environmental advocacy circles particularly, and it's transforming environmental law in lots of really interesting ways. But the foundations of it really stem from First Nations and Indigenous law, LORE, as well as LAW, and the way that they conceive of their relationship with the environment and the world around them. So most of the successful examples that we're going to talk about today are really grounded in Indigenous understandings of relationships between people and nature, and that's often obscured, I think, when we frame this as a specifically environmental issue. So that's the context, I think, for what I want to talk about today. I'm just going to open that. I feel like it's... Let's see. All right, let's try that. So, legal rights for rivers. I think this has been a really exciting legal development, but it also sets up some really interesting tensions and challenges. So I like to think about it in terms of the paradox that it creates, and I'll go through what I mean by that paradox a little bit later in the presentation. But effectively, what we're seeing is a real strengthening of legal protections, and yet at the same time, a change in the way that people are seeing the environment and their relationship to it. And that change can weaken people's willingness to actually protect the environment. So that's the trade-off that I see underpinning legal rights for rivers. As Cameron talked about, this is not a particularly new idea. The seminal paper is Stone's 1972 article on whether trees should have standing. This is an idea that's been kicking around on the fringes of environmental law for a really long time, but in 2017 it really started to come to the forefront. So again, this is building on really a decade of action that saw legal rights for nature embedded within Ecuador's constitution, 2010 law that was passed in Bolivia, a number of smaller events that have happened throughout the US and in other places. But in 2017 it became about rivers. 4 rivers became legally people. The first one was the Wanganui River in Aotearoa, New Zealand. And this was very much the result of negotiated outcomes between Māori and the New Zealand government about treaty dispute, the Treaty of Waitangi, and giving the Wanganui iwi the rights that they had under that treaty. So the rights for the river were in fact in that instance a really pragmatic outcome, a circuit breaker between the interests of the Crown and the interests of Māori. So the Crown was very reluctant to cede ownership of the riverbed to Māori. Māori, on the other hand, both within their internal construction of what the river is as an ancestral being and in their claims under the treaty, were quite clearly claiming the river for themselves. So the circuit breaker became, well, let's let the river own itself. We'll set up institutional arrangements that create a co-management set of institutional arrangements, but it was very much a kind of, let's just see if this idea will get us through this negotiation hold point. And so headlines went around the world when this river became a legal person, but at its heart, it was deeply pragmatic in a way of acknowledging Māori relationship to the river, but avoiding handing over ownership to Māori. The second river I want to talk about is the Rio Atrato in Colombia. So this was a constitutional case in Colombia. The Colombian Constitution recognises a human right to a healthy environment. There are specific communities that live along the Rio Atrato. There are 7 main communities. These include Indigenous peoples as well as the descendants of former slaves. And so both of those communities receive special protection under Colombian law. And so the Colombian Constitutional Court argued that, or held in fact, that in order to protect the human rights of these communities, they had to recognise the rights of the river itself. So it was a kind of biocultural right that intertwined humans and the river. Again, in that case, although it was formally decided in advance of the Wanganui legislation, it drew quite heavily on the New Zealand examples, and it tried to set up, the court was quite activist in setting up some new institutional arrangements to actually give effect to the new management of the river. The case was run by NGOs representing the interests of those communities. I am uncertain about how the implementation of the court's decision has continued, but one of the really exciting things that happened was that the government almost immediately embraced it, the government of Colombia, and then went back to those communities, those 7 communities, and said, how can we give effect to this? The court has effectively nominated a guardian in the Ministry for Environment, but that's quite inappropriate both on sort of a fundamental level, but also on a geographical level. Bogota is quite a long way away, and the terrain makes it very difficult to get from Bogota out to the Rio Atrato. And so government's response to that was to say, well, why don't we have guardians that come from the communities? And so they ended up with 1 man and 1 woman from each of the 7 communities, as well as the Ministry for Environment being guardians for the river. So as an implementation framework, again, this was a really sort of rich response to the problem of how do we manage the impacts to the river. The Ganga and Yamuna rivers in India took things in a slightly different direction. So this decision was handed down by the State Court of Uttarakhand, the High Court, very early in March. It's been followed by a number of other similar sorts of judgments, both in Uttarakhand and in other states, although generally, as it turns out, by the same judge. So there's a particular judge in India that thinks this legal rights for nature thing is really the best way of protecting nature in almost all its forms. So they recognised, based on really a couple of different things, the need to protect the rivers, acknowledging that they were really heavily impacted, and the Ganga and Yamuna rivers are certainly some of the most damaged rivers anywhere in the world, but also the sacred nature of those rivers. And there's a line of legal precedent in India that recognises legal personality for deities and sacred objects. But of course that's problematic in the Ganga and Yamuna rivers. This was a state high court, so it immediately set up some jurisdictional problems that recognised the entire Ganga and Yamuna rivers as legal persons, nominated members of the state government to be their guardians. The state government was like, but how? Our jurisdiction ends at the border. What do we do with these rivers? We already have a number of organisations that operate throughout India with responsibility for managing particularly the Ganga River. The second problem was grounding it in that idea of sacredness. So on the one hand, I think that's a really interesting way into this question of legal personality, but on the other, it effectively excluded those who didn't have that sacred relationship with the river. So the court specifically said that it was sacred in the Hindu religion, which meant it was sacred to half the Indian population. Of course, the other half immediately felt a little aggrieved. This decision was also handed down in the context of a Hindu nationalist movement, which is ongoing in India. So the broader ripple effects of that particular construction and the linking of the specialness of the river to its sacred status in a particular religion ended up creating some challenges. For the Ganga and Yamuna rivers particularly, this is probably one of the least successful examples that I'm going to talk about today, because the state government immediately appealed. So this decision, the effect of the original High Court decision has been stayed. The rivers are kind of in limbo while the Supreme Court figures out how to rule. So rivers started to become people. Again, headlines echoed around the world. There was a lot of interest. What does it even mean? So I think the first question we have to ask ourselves is, what is a legal person? What are we actually conferring on nature when we give them personhood? It's not necessarily a human person. Human persons are, of course, legal persons, but it is a fairly profound statement of who matters, of what matters to the law. Legal personhood is to become a legal subject. It means that you are visible to the law in ways that objects simply aren't. So it's an entity capable of bearing rights and duties. Legal personhood specifically brings with it three distinct rights and duties: the ability to enter into and enforce contracts, the ability to own property and to deal with property, and of course the ability to go to court, to the ability to sue and also to be sued. And so it's this question of legal standing which is where most of the interest in this concept of legal rights for nature has been embedded. It's the idea of creating a level playing field in the eyes of the law, letting the environment go to court to speak up for its own interests. Now, since 1972, when Stone was originally throwing around this concept, of course standing law has changed over the past almost 50 years. It's now much broader. It's much easier for organisations representing the interests of the environment without necessarily having to show impacts to humans to go to court to protect those interests. It's limited and it's often legislation specific, but it is easier. But these are the three kinds of legal rights, and you'll see that in none of this is there any kind of human right element. So a lot of what we think about as our rights as people don't necessarily play into this construction of a legal person. So this is what we're really talking about when we recognise nature as a legal person. It's not the same as a human being. So what happens in Australia? Lots of rivers, lots of other natural entities around the world are starting to get legal personality and legal rights. Do we have anything like that in Australia? There's a couple of interesting examples, and I'm going to come back at the end of this presentation to some kind of unfolding examples that are, I think, showing some sort of hotspots that we can keep paying attention to in the Australian context. The first example that I wanted to talk about is the Birrarung Council that Cameron mentioned at the start. So I'm a member of the council. We are a voice for the Yarra River. This legislation was passed in 2017. The photo that I have here shows Wurundjeri elders speaking on the floor of Victorian Parliament. This is the first time it has ever happened. The legislation, the preamble and a number of pieces throughout the legislation include Woiwurrung language. So there's a bilingual element. It's certainly not bilingual legislation, but there are bilingual components to it. And I think, again, that's an Australian first. So this entity is to speak on behalf of the river, to voice the river's interests, to advocate on behalf of the river. Our twin roles under the legislation are to advise the Minister, particularly on the implementation and development of the Yarra Strategic Plan. I'm happy to talk in more detail about that. But also to advocate for the interests of the river. And so we're still thinking about how do we do that. But I think the interesting thing here is that the legislation recognises the Yarra as a living and integrated entity. And again, that's an Australian first, to acknowledge a river as a living entity. But it's not a legal person. So it's kind of raised the visibility of the river in the law, but it certainly hasn't hit the heights of a legal subject. The Birrarung Council has 12 members. There are 11 currently because there is some contested land between Wurundjeri and Bunurong, the traditional owners of the Yarra catchment. And so we have 3 Wurundjeri elders as part of the council, and there's a seat held pending the outcome of that contested land. So a voice, but not a legal person, not specific legal rights for the river. The other really interesting thing, and this is what much of my book spends its time talking about, is the way that environmental water managers, can start to be a kind of indirect form of legal personality for rivers. So environmental water managers in Australia are legal persons. The Commonwealth Environmental Water Holder is a legal person. The Victorian Environmental Water Holder is very clearly a statutory body corporate legal person. I've got some photos of the previous commissioners up here. Unfortunately, Dennis Flett seems to have slid off the side of that photo. 2 of those commissioners have just been reappointed, and we've got 2 incoming commissioners in the Victorian Environmental Water Holder. Reuben Berg, which this one here, is an Indigenous man. He's a Gunditjmara man, so I think possibly still sleeping off the hangover from their very exciting World Heritage listing for Budge Bim. I don't know if any of you were following that over the weekend, but this is Australia's first site. It's down in southwestern Victoria, the first site in Australia that's received World Heritage listing for its cultural values. It's an incredible landscape, and I would definitely encourage you all to visit it. So these organisations, we've got Jodie Swirapik down here, the Commonwealth Environmental Water Holder. These organisations have a responsibility to speak on behalf of rivers, to act on behalf of rivers. They hold water rights, they participate in water markets, they make choices and decisions, and they are a form of attenuated legal personality for rivers, only in those rivers where environmental water rights are held by those organisations. There are similar organisations in the United States that are performing a similar sort of function. So in this case we have legal personality, but not necessarily a clear voice for the rivers. So Australia is in a bit of a middle ground. Lots of interesting capacity, I think, for developments in this. We're very unlikely to see it come through a judicial decision, but there's lots of space for legislative reform. So let's go back a step and think about why would rivers actually need these kinds of rights? What are the sort of justifications that people have used? First Nations law. So I alluded to this at the beginning. This is a profound driver for the recognition of nature as a person, as a legal person. First Nations and Indigenous law in lots of different ways, depending on which context you're talking about, constructs its relationship, or constructs people's relationship with country in the same way that people relate to people. So rivers become an ancestor, there's a strong guardianship relationship, there's that custodianship relationship. So recognising that as the cornerstone has often been a trigger for recognising rivers as people. Ecocentrism is, of course, one of the big drivers, and this is that sort of environmental advocate movement, raising the environment in the court, in the eyes of the law, so that you can have a level playing field, so that the environment has the same kinds of rights as other users of the environment. Market environmentalism, which sits quite uncomfortably next to ecocentrism. But this has been particularly a strong driver in places like Australia and the US around environmental water recovery. So enabling the environment to actually participate in markets, make those kinds of choices, use legal personhood and personality in a way that reflects agency. Market environmentalism has been a strong driver for that. And that's quite unexpected, I think. When I was writing my thesis a few years ago, again, that juxtaposition is uncomfortable and unexpected. People who sit within the ecocentrism camp are generally not market environmentalists. So there's a bit of unexpected outcomes going on. The fourth thing, which I think is really interesting, comes from regulatory theory. And this really gets back to the idea of why is it important for the environment to even have a voice? And that depends on which kind of theory we're adopting for the way that regulation is made. Do we see it as a kind of public interest process in which it's the job of bureaucrats to go out there and understand the interests of the vulnerable, to create very purposive, intentional regulation? Or are we more private interest people who see it as regulation is nothing more than the emergent property of competing interests? So everybody lobbies and then you get what you get. And it's the job of the bureaucrats to kind of facilitate those interests coming forward, not necessarily to insert their own understanding of what those interests are. And this is really, really profound when it comes to the importance of legal rights for rivers. So I like to construct these ideas as quite competing visions for what the role of regulators actually are and the role of government is. So all of you West Wing fans in the audience will recognise this quote from Aaron Sorkin. I think it's Toby who says it in the West Wing, where government should be a place where people come together and no one gets left behind. So in that case, the environment doesn't really need a voice because it is the job of regulators to look after its interests. Now, obviously we end up kind of in the middle because no regulators are actually perfect at doing that job. But a voice isn't particularly necessary in that space. But if you're in a private interest competing framework, a voice is absolutely necessary. The environment absolutely needs to speak up for its own interests. When we were creating the Victorian Environmental Water Holder, so this is going back, and I say we, I was working in the state government at the time, and it was my job to create the Victorian Environmental Water Holder. it was considered essential to give the environment a voice, to enable it to speak on the same sort of level playing field as other water corporations and other users of water. That very quickly translated into the environment being just another user of water, and led to phrases that the Commonwealth Environmental Water Holder likes to use along the lines of being the biggest irrigator in the basin. So again, framing the environment as a user of water particularly. And what I found interesting here is that as soon as you subscribe to the idea that the environment needs a voice, you've accepted that actually the predominant way that regulation gets made is through competition. So giving the environment a voice is a really profound statement about what we expect it as its role to be in making regulation. So again, I think that's a kind of unexpected outcome. Environmental advocates like to push legal rights for nature without, I think, having a lot of thought about the implications, which narrative you're actually signing up to. So what actually happened once rivers started to get their rights? The Yamuna River was reported as murdered. So the file remains open and unsolved. The reason why the Yamuna River was reported as murdered as opposed to any of the other rivers, and murdered as opposed to destroyed or something else, is because the judges in that case blurred the line between living and legal persons. So they created a kind of hybrid entity that had aspects of both a living person and a legal person. You can't kill a corporation, you can't murder a corporation, but they did argue that the Yamuna River was murdered. New rights for nature have proliferated around the world. So Aotearoa, New Zealand has seen a number of, so Mount Taranaki is on track to get legal rights. There's been a number of other rivers that are now being looked at in that space as well. They already have a national park, Te Urewera. Colombia, the Constitutional Court decision has led to a line of precedent. So we've seen legal rights extend to the Amazon, which was a climate change related decision, and there's been since, I think, 2 additional rivers that have now received legal rights from lower courts. India, again, I mentioned this earlier, the same state high court that gave legal rights and personality to the Ganga and Yamuna rivers gave it to all of nature in the state of Uttarakhand, and then all of animals, most recently last year in the state of Uttarakhand. Bangladesh has just recently recognised all its rivers as legal persons. There's some really interesting stuff coming out of that ruling. Again, the Bangladeshi courts tend to be quite activist, so the court has set up a whole lot of institutional arrangement kind of expectations in its judgment, including a whole bunch of penalties. The USA has been a really interesting testing ground for a lot of these ideas. They've been driven by environmental advocates. They've tended to happen at local levels. So of course, as soon as you get a jurisdictional challenge or a constitutional challenge, they tend to fall over. The most recent example was Lake Erie, which happened this year. It's already under pressure. So they passed the ordinance and almost immediately people started suing on the grounds that this was both jurisdictionally inappropriate and constitutionally inappropriate. So in terms of the outcomes, we can start to see some really strong threads and tensions between different responses. So we get a strong collaboration and co-management response in some cases. Colombia and Aotearoa particularly are focused on co-management as a response. But competition and fear is also a really strong reaction. So of course, India, the guardians, the state government guardians, rejected that outright. One of the reasons was that jurisdictional problem. Yes, they couldn't take action beyond their state borders. But the other reason was that they were very afraid that as guardians, they were going to be sued the next time those rivers flood. So from protecting the environment, to enabling the environment to protect itself, to being afraid of the environment and having people sue the environment for the damages it does to human beings, was a very quick process. And that's the danger of legal rights for rivers and legal rights for nature more generally. In both Aotearoa and Colombia, although they've been quite strong with the co-management approach and the collaborative approach, they have not included property rights. In the case of Colombia, that was explicitly excluded for the river. And in Aotearoa, New Zealand, the river does not own any water. It's a river without water. So I don't even know, like, existentially what that means. It was a very specific reason in that case. The Maori chose not to include water rights as part of their treaty dispute negotiations. But again, it sets up some really difficult outcomes. And this, I think, leads us into the paradox of legal rights. Rivers can definitely take more action to protect themselves once they have legal rights. They are visible to the law, they have a whole lot of extra legal tools and legal powers that were not at their disposal beforehand. But people are much less likely to want to protect the environment once you frame it as a legal person. And that transformation happens very quickly. So I've given this kind of presentation in lots of different contexts. It astonishes me how quickly the first question often comes back, and it happened when I was talking about it with my water law master's students just a couple of weeks ago. Can we sue the rivers then? Like, how can we start, what does that mean for people? And I just, from water governance perspective, that's a concern. We can lose the narrative so quickly when it comes to river management and river protection if that's what we're setting up as the outcome. So to understand this paradox, I think we need to think about what we're actually doing in environmental law when we construct the environment. And so this was, I think, really the major contribution of my thesis and my book is to try and say, well, let's think about the way the environment is actually constructed in law. So if we go back to the beginnings of environmental law, back in the sort of 60s, when the law started to recognise the environment as more than the sum of its parts, it had to recognise that physical reality and then translate it into this kind of socio-ecological concept in law. So it's more than just the bits and pieces that we can see around us. In doing so, it had to start to describe which bit of the environment matters. So the environment is everything, literally everything around us. And the very first job of law was to say, we're going to recognise that, but we're also going to start defining it. That brings flexibility, but also it's a narrower perspective each time. You've got to be explicit about what you're talking about. Once we've recognised it, law then began to translate it. How do we protect the environment? Where we start placing limits on the way that other people act. It's an object in the eyes of the law. And then we start to think about what does it mean when we personify the environment. You'll notice that it keeps getting more specific. It's quite difficult to personify something which is very broad. They gave it a good solid try in places like Ecuador with rights for nature on a very general level, but most cases are starting to focus personification on specific natural entities. And this is, I think, why we end up with the paradox, because of the underlying narratives and the specific vulnerability that comes with that socio-ecological concept. So a legal object unites these ideas of weakness and worthiness. So the environment's too weak to look after itself in law when it's a legal object. It literally has no rights and powers. So we protect the environment because it's the right thing to do. It's weak but worthy of protection. When it becomes a subject, it can and therefore should look after itself. Western legal frameworks in their construction of legal persons particularly tend to link, well, we've given you the rights, so now it's your job. It's your responsibility, if you've got rights, to go and enforce that. There's some interesting alternative models coming through in the disability law space, which I'm happy to talk about, but that's generally how it ends up being constructed. So once it's a legal subject, the environment, well, we tend to rely on it using its voice. It's that private interest regulatory theory stuff. The reason why we end up with the paradox is because of the vulnerability of that socio-ecological concept. Whenever the law recognises the environment, it has to be specific about which bit of the environment it's talking about. So flexible, but vulnerable to shifts in those narratives. So this tension affects what the environment is, how we care for it, whether it's our responsibility to look after it. This tension is profoundly impactful on the environment in ways that it's not for other things that we try and use the law to protect. So I think legal rights for nature can be a really powerful legal tool, but we have to acknowledge the difficulties and the tensions that we're setting up when we do. So I'm going to try and finish up with some lessons and then some of those hotspots to keep an eye on. So resolving the paradox. This is what I'm spending a lot of my time thinking about now. Encountered a bit of a problem, what do we do about it? I think we need a new model for an environmental legal subject. There's lots of thinking going on in this space. Is it an ancestral legal being? Do we specifically draw on Indigenous conceptions of country and the environment? I kind of like the idea of a living and integrated entity. That's something that New Zealand is now starting to pick up on as well. That's the model that we've used in the Yarra. It lacks legal rights, so I think there's some trade-off stuff that's going on there. But I think thinking about what a new kind of legal subject looks like for the environment is important. The second lesson is to actually directly target that down arrow. We need to maximise people's willingness to keep protecting the environment, to not abdicate our responsibility, to not fall into the trap of this competitive adversarial relationship with the environment. Two of the ways that have been really successful so far has been to centre First Nations and Indigenous people and their values, because that creates a new space, particularly for white people like me, to think about my relationship with nature. As part of that, connecting people in place. And so that's something that's happening specifically in the Yarra, and I'll talk about some of the other Melbourne examples very quickly. Thirdly, and this is not unproblematic, if we expect nature to compete, we have to give it a level playing field. So it needs institutional arrangements. It needs organisation and funding and governance arrangements that actually let it stick up for itself. Because if you don't, then you've given it the appearance of a level playing field when in fact there really isn't. And that's the risk that we're running right now. So I'm not a big fan of that third lesson, but if we're serious about giving nature right to sue, then we need to be serious about that as well. So these are the hotspots to keep paying attention to. I've talked a little bit about the Bear and Council, and I'm happy to go into that in more detail, but there is a wide array of programs across Melbourne now. There's the Yarra, which is leading into a kind of implementation phase. There's the Waterways of the West Ministerial Advisory Committee, which is thinking about how do we connect people in Western Melbourne. There's the Barwon Ministerial Advisory Committee out near Geelong doing a similar kind of thing. So urban rivers and the communities that live along and near them are being given increased opportunities to think about how do we want to live with rivers? How do we change the narrative from what do we want from the river to what do we want for the river, and ultimately how do we get there with the river? So lots of interesting, I don't know what's going to happen with a lot of those things, and it may not end up in the places that I'm hoping it will go, but really interesting opportunities and possibilities. The other one is the Matawarra Fitzroy in Western Australia. This is a really exciting space to pay attention to. So the native title holders in the catchment have gathered together to create a declaration on behalf of the river, to recognise the river as an ancestral being, to start to claim a guardianship responsibility. They're lobbying very hard for the state government in WA to actually recognise their relationship with the river and the opportunities that creates. So again, pay attention to that bit up there. It's under tremendous pressure from a water management space. There's a lot of pressure being placed on it for future irrigation development, but the way into that conversation that traditional owners provide is a really exciting opportunity. And that's where I'll finish up with a plug for my book.
So I think we'll take the questions. Are you happy to run questions yourself?
Sure.
So to take it down to kind of a water management level, I guess, so look at it through a slightly different lens. General good practice would say it needs to be strategically integrated as a management. One that you had in your reflections on kind of the harmonization, so making sure more about individual rivers rather than saying the whole catchment, or whether the whole catchment's included in that process. So what does that mean for integrated water management? The second one was about how the management operates in the river itself. So whatever microbes, fish, we might have invasive species holding the banks up, for example. How will the other rules that affect what happens to those animals and trees and stuff interact with kind of the legal rights themselves? The third one about the funding, do you see that as being public funding? Or if not, where is that going to come from? Is it going to be from the broader community or private? I'm skeptical about public funding going towards something like that. And the fourth one is why rivers and not groundwater or whatever else, and how those different bits of water interact.
All right. So to work through those, so the first question was about integrated water management, and I think it kind of ties in with the final question about why rivers and not other things. I think what makes this successful is the connection between people and place. So why a specific river and say why not the Murray-Darling Basin as a whole? You could certainly use legal rights or extend legal rights to the Murray-Darling Basin as a whole and then say, well, you know, now it's your job to push back against and to have a voice into water management decisions. But you'd have to ask yourself, well, what would be the added benefit of doing that? Why would a voice for the catchment actually be useful in that context when we have a whole bunch of state and federal organisations that already have responsibility for managing in a sustainable way? That was one of the criticisms that was made for the Gunja and Yamuna decision. So there are already multi-state and multi-country bodies with responsibility for doing that. So I think you have to have a very clear idea about what problem it is that you're trying to solve when you create legal rights for rivers. In the Yarra, and I wasn't involved in the creation of the legislation, but there was a recognised need for integrated management across the entire catchment. So again, in possibly in Australian first, certainly Victorian first, the legislation links land use planning frameworks and water management. And so the job of the Bureau and Council is to look across the top of all of that and say, is it actually achieving a net benefit for the river, and how are the river's interests reflected in that integrated management process? So I think in that instance, it was a way of strengthening the integration, filling a role that nobody was actually filling at present. Lots of organisations were doing very specific things. No one was taking an overarching view. And formalising the relationship between the community and the river, specifically the Indigenous community, because they had been almost entirely excluded from water management generally in Victoria, which is a problem generally in Australia, but also the broader community. I think Melburnians have come to really love their river. Like 20 years ago it was the Brown River that was an embarrassment and it was upside down, but now we've come to realise actually it's an incredibly beautiful place. It plays a really important role in many people's lives. So raising the profile of that river within the legal framework was really important. I think, the Yarra is probably the model that I would lean on for that integrated water management response. In terms of why rivers and why not other things, I think there's two layers to that question. So I think it's important to be specific when we give rights to nature. The Ecuadorian example where rights were extended generally, I think created a problem where they became everybody's responsibility to enforce, and so kind of nobody's responsibility to enforce. Specific NGOs have run specific cases, but they tend to run out of funding before they can actually get stuff done. So having a specific focus for the personality and for the guardianship, I think is really important. And again, it's then grounded in place. So you're strengthening a relationship between people and place rather than setting up this entity as a competitive player. Why rivers and why not the other invisible elements of water management? I think it's partly because they are invisible. So it comes down to the way you define what a river is. So the Wanganui legislation, for instance, talks about the river from the mountains to the sea, the river and its catchment from the mountains to the sea, including all the physical and metaphysical elements. So it's a very broad definition of what the river involves, even though it excludes water rights. So I think there's capacity to make sure that a definition of river is not just the stuff that happens between the banks, but is actually broad enough. And then the last question there was about funding. This is probably where I'm straying into a personal philosophy rather than anything else, but I think it needs to be public funding because I think these are public good outcomes. So they need to be for all of us, and it needs to be a process which ties back into democracy and what we actually want from our elected representatives. There's a place for private funding, absolutely, but yeah, I think it belongs in the public space. It's going to be really interesting to see what happens in Victoria. So we've been through this incredibly complicated process with the Yarra legislation. Some of the other processes are starting to think, is there capacity for a more generic piece of legal reform? I think there are two sides to that equation as well. So place-based legislation can be really complicated, and you end up with a proliferation of laws, and every single process that you have to go through to get each piece of legislation through is very long and difficult and expensive. But each piece of legislation is an opportunity to champion the relationships between people and country, and specifically to start to redress the historical injustice and exclusion of Aboriginal people. A more generic reform enables you to avoid some of those long, difficult processes of getting legislation passed, but it still requires you to think about, well, what piece of subordinate legislation are we going to use to actually set up these new arrangements? If people want their river to have a voice, if we want to use it as a measure of justice as well, then can we get away from place-based legislation? I'm not sure that we can. Yes?
I wonder if a river has legal personhood and it's then managed, say, in the case of the Rio Trato, managed by local communities, collectively. Do we know whether they're necessarily acting in the interest of protecting the environment of that river, or whether they perhaps might say, irrigation rights upstream is fine because that generates income for us here, so we can manage them downstream, etc. Do we just transfer our general problems onto another legal entity? And I'm asking that because I think the idea behind all of this presumably is to protect the river, or protect the environment more broadly, but by giving legal personhood, you also, as you said, create these responsibilities. And so it seems to me that perhaps there is more unintended consequences than benefits.
There certainly can be. I think there's two ways into that. So I think there's a question of how separate people are from their environment, and then there's a question of how do you hold an organisation to account. So tackling the first bit, or the second bit first, we can create really clear obligations as part of creating those legal rights that specify what outcomes the river is trying to achieve. So again, the New Zealand legislation has a number of these principles that underpin the role of the guardian. So one of the things that happens in the US, for instance, with the environmental water managers, they have very clear legislative roles to play. They can find it a little challenging to fulfil on all of those when there are competing political interests. So the role of third parties to hold them to account for that can be really important. And I think in that kind of case, you could actually start to rely on, that could be the role for NGOs in that space, is to continually make sure the guardian is actually doing what they're supposed to do on behalf of the interests of the river. The more fundamental question is, how separate are the interests of people from the river? And I think within a Western legal framework, we tend to think in terms of trade-offs. And we often see humans as quite distinct from the ecosystems in which we operate. So I think we need to start learning much more about the way that Indigenous peoples construct that relationship. So again, there are the principles in the Wanganui legislation that embed a Māori worldview. And I can see the same kinds of things playing out for Aboriginal people in Australia, in that economic outcomes are really important, like being able to put food on the table, and Māori will talk about that as well, jobs for the next generation, all of that sort of stuff. But they frame it very differently, and they don't construct the same kind of inherent trade-offs that we see playing out, or that we enable to play out in the sort of environment versus development framing that we tend to get stuck in. It's not an absolute thing, but I think there's a more complex space there. So one of the things I've been thinking about is a kind of eco-cultural model of humanity. So spending time with Aboriginal people, it just crystallised for me when I was down at Budge Bim, in fact, and recognising that they have a model of humanity in which humans are both just a part of the ecosystem, but also fully retaining human agency. So managing elements of the ecosystem. So those of you who've read Dark Emu, Aboriginal people have been farming the land for a long time, but doing it in a way that is mutually sustaining. And so I think that's the kind of more profound piece of work that we need to do. Legal rights on their own will not address any of those problems, and in fact could worsen them. But if we're serious about it, then we need to start thinking much more broadly about what people are and what our relationship is with the environment. Yes?
Fascinating talk. I'm just thinking, have you had any experience with pushback to all this? You can imagine that some political ideologies or big business think of this as a Pandora's box that's now being opened. And so what have you felt or experienced in terms of people trying to lobby against it or protest against this way of thinking nature?
Yeah. So there's definitely, it can fracture communities quite clearly and quite quickly. So again, looking at what's happened in the US with Lake Erie, the origins for the push to grant legal rights to the lake came from a blue-green algae event that happened, I think, back in 2014. And it basically cut off water supplies to the town of Toledo. So everybody in the town was kind of unified by this common experience of, my God, water quality really matters. Like we have to do this because it's underpinning everything that we depend on. So I think this unifying event gave rise to the idea of, well, maybe the way to do that is to give legal rights to the lake and then we can start protecting it better. Once the ordinance had passed, it was so people immediately took action. Farmers were campaigning against the ordinance being passed in the lead up to it. So it was the city of Toledo that passed this ordinance. Because they could see that granting the lake legal rights was going to be a way of managing pollution, and they could see that most of the nutrient runoff was coming from farms. So for them, it was a very clear signal that this was going to be a litigious approach to protecting the environment and that they were in the firing line. That, to me, you can see that response play out in a lot of environmental legal protections, particularly in the US. Less so, I think, in Australia, where we tend to find other ways of lobbying against these things. But that's the real danger of legal rights for rivers, is that it creates that adversarial reaction. And again, what's the purpose of having a right if you're not going to enforce it? So people start expecting that maybe you will, and they start seeing their own vulnerabilities to that. So yeah, it's a risk. Lauren.
Thank you very much for that. I think my question is kind of related, but a bit more of a legal to that, and that's to say that there are other areas of particularly greenlighting, where the public rights element of the law has just dominated completely, and that this kind of governance model, as it stands in the current way, just is not going to be seen in the same light because of the heavy focus on public rights and nationality. Understanding that there is a different legal relationship of rivers to the public rights doctrine, but I'm just wondering why there hasn't been a focus on public rights in relation to this, or has there been and it just wasn't sort of dealt with today?
So I think it's a very context-specific thing, and so public rights in places like the UK, I think that would be a really interesting space if we saw the push for legal rights there, because there are such entrenched public access rights for many rivers and for many landscapes. That could create a really interesting, interesting tension between what are the rights of the river in this context. I think. Yeah, the Yarra is an interesting one as well, because one of the outcomes of the legislation is, ideally, working towards this idea of the Greater Yarra Urban Parklands, and so extending public access connectivity all the way along the banks of the river. And so, does that start to create some public access rights, which may then start to conflict with the interests of the river? It's certainly already starting to conflict with the interests of traditional owners. So one of the outcomes of the giant new road that Victoria is building at the moment, the North East Link, is going to be some investment in additional footbridges and various actions to increase public access to the river. Some of the preferred locations for those are in the bends of the river. That is where you are most likely to find cultural artefacts. And it's where traditional owners repeatedly say, please don't build there, because, so there's already, I think, layers of tensions emerging in that context as well. But yeah, I think,
That's interesting. It's some of those emerging land and coastal marine spaces front up.
Yeah.
You need that first. So that's really interesting.
yeah. I'll be watching with interest to see how that one plays out, because I think there's increasing interest in, like, the mountains to the sea in the Wanganui starts to have implications for that estuarine intersection. Yeah. Yes.
Again, thank you very much for a very interesting discussion. I'm interested to understand what is the level of momentum in Australia in moving towards and who are the main players in that, and whether
Okay, so, at the last meeting of appeal, can you remind me of what those letters stand for? Thank you. The Australian Panel of Experts for Environmental Law. There was a discussion of legal rights for nature and the opportunities that it created for furthering environmental law reform. So it's now definitely becoming part of the mainstream conversation of environmental law. It's throwing up a lot of challenges. I think in the Australian context specifically, it's extremely unlikely that we would get there through a judicial ruling. So the role of EDOs would be more about legislative reform. And I think there is not a clear enough case, I think, in Australia for the creation of legal rights for nature specifically. Although, again, I'd be really interested to see what would happen with a stronger partnership between Indigenous people and EDOs, because, and again, Indigenous Australia's reaction to the concept of legal rights for nature has been ambivalent too. So some people see that as a way forward for recognising their relationship with country. Others see it as fracturing that relationship because now nature is quite separate from people. So, there's no real easy solutions. I think the Yarra and the Marrawara models, they are some really interesting kind of forward-looking ways of thinking about rivers and river management. There's the programs for swimmable rivers. So I think Sydney has one. There's certainly one in Melbourne. I think Brisbane's got one as well to try and transform the way we think about urban rivers. Ties into a bit of the water-sensitive cities concepts. So there's definitely a push to celebrate rivers in urban planning and land use in ways that we haven't before. Victoria's new stormwater management protocols and policies are creating a real opportunity to change water quality in rivers, which then again enables us to be closer to the river. Like, you still don't really want to get that close to the Yarra in its lower catchment. It's beautiful and I love it, but So in terms of who's really leading that, EDOs, Environment Justice Australia, have been heavily involved in the Victorian examples. So one of the reasons we got the Yarra legislation we did was because Environment Justice Australia ran basically a parallel process to the Ministerial Advisory Committee that was grounded in community engagement and community participation to say, what is it that you want for your river? And they're doing the same thing again with Waterways of the West to try and give communities a voice into that space. So I think that's probably where the role of EDOs and Environment Justice Australia kind of organisations sit. I'd be really wary of any organisation that was, I guess, really trying to lobby for the creation of legal rights for nature. There are specific organisations around the world that do that. I'm quite a fan of ecological jurisprudence. I'm nervous about the application of this particular idea because there's not been a great deal of engagement with the outcomes and with the evidence base and with trying to understand the implications of it. So that's something that's coming through already in the Bangladeshi context. So I don't know if you guys, there was an article that came out, I think last week. Poor communities along the banks of the rivers in Bangladesh are now at risk of being forcibly moved on because of the really stringent requirements that the court is imposing to protect the rivers, and they will be felt primarily by the poorest who are living in the slums alongside them. So protecting the interests of the environment, but also the interests of people, is still a challenge.
Thanks for that cheery. So thanks to everyone for coming along for today's talk. I really appreciated the great questions, and let's all thank Erin again.